So in the previous sessions, we have covered MDA, we have covered some of the hybrid maritime threat, and in these sessions, which is also closely linked to the previous topic, on the rules of the roads for non-traditional and cross-cutting maritime domains, we have the privilege to invite His Excellencies Ambassador Andrew Goled-Zinowski from the Australia Embassy to Vietnam. Thank you so much, Ambassador.
Thank you for that nice introduction. Please, everyone, feel free to call me Andrew, or Ambassador Andrew, if you want to be very polite. Well, look, Sean made it very tough for me because he set the bar very high, but I think this is going to be a very good session. And I really want to kick off by congratulating the DAV on what has been an outstanding conference. I've really, really enjoyed it, and I'm very proud that the Australian Embassy is a supporter of this important activity. This session is on the rules of the road for non-traditional and cross-cutting domains, which I think nicely complements the session which we just had. I'd like to frame it with the following comments. Until recently, there was an active debate in Europe about how to manage Russian ambitions, whether it should be done through increased cooperation or through increased balancing and classic deterrence. That debate is now over. It ended on the 24th of February. The question for us here in this region is what lessons will we draw and apply from that to our situation? And in particular, what does it mean for the rules of the road in these non-traditional and cross-cutting domains, such as under the ocean, in space, and in cyberspace? To help us unpack some of these questions, we have a distinguished panel of experts, and I won't be introducing them individually in detail because you have that information in your pack. But I would like to start off by welcoming Dr. Alina Noor, who is actually joining us from cyberspace. Dr. Noor is the Director of Political Security Affairs at the Asia Society Policy Institute in Washington. And Dr. Noor, I think it's about 10:15 p.m. in Washington at the moment. Is that right? I hope you can stay awake for the balance of this session. Dr. Noor, we're looking forward to hearing your remarks.
Thank you very much, Ambassador Andrew. It's been a while since we last saw each other in Malaysia, but I hope you're well. I have to dispel a bit of misinformation because I'm going to be talking about cyberspace. I'm not a doctor, I'm just Alina, so happy for everyone to be calling me that. It is pretty late in Washington, and it is a challenge for me to be coherent on a regular day in the sunlight, and so I hope I'll make sense with the few remarks that I'm about to make. So 3 points to offer to you for discussion. The first of which is I'll be talking a little bit about the intersection of cyber and maritime through the lens of some of the advanced persistent threat incidents that we've seen over the years, mainly around the 10-year period or so over the last years. And then I'll offer some thoughts about what this means for international law and rules of the road moving forward. Finally, ending on some thoughts about how we in Southeast Asia might think about the ways ahead. So first of all, the incidence of advanced persistent threats, or APTs as they're more commonly known. So APTs, if you're not already familiar with the term, refer to campaigns, sustained campaigns over periods of time where there has been penetration of a system or a network by an external perpetrator, malware usually, and that lives on in the system or network, mainly quietly to collect information. Basically, it's espionage, but what is done with that information and what happens after the information is collected is what is of importance and significance to us, particularly with regard to the militarization of the South China Sea seascape. The incidence of APTs actually goes back quite a number of years. I mentioned about a decade. We're now in 2022. The earliest incidents of APTs that have been tracked by private sector cybersecurity companies, and there's been a range of them, from Kaspersky to F-Secure to Threat Connect, has indicated that the APTs go back to at least 2007. So we're talking about 15 years worth of information collection. Many of these companies identify these perpetrators to be in kind of the time zone that you are in right now. China, Vietnam, Malaysia, Indonesia. Timestamps have indicated that the perpetrators come from the region where the South China Sea dispute is. And these APTs have mainly targeted government agencies, energy companies, telcos, educational institutions, even the ASEAN Secretariat has been a target. Now, this time period correlates to the reclamation and massive expansion of nearly, according to AMTI, of CSIS, over 3,000 acres of land in the South China Sea. I'm not saying there's a causation of what has taken place in cyberspace and what has taken place in the maritime domain, but there are certainly dots to be connected, if not questioned at the very least. So given what we know about these APTs, there is an implication for how international law applies, whether it applies at all to some of these activities, because espionage, as many of you international lawyers know, is not an offense in international law. It is in national laws, but basically it's a gray area in international law. And actually, some of this information collection is embedded in military doctrine, for example, in the US military. So what do we do with these acts of information collection, espionage, whatever you want to call them? There are arguments among legal scholars that espionage could potentially be considered as a threat of the use of force under Article 2, Paragraph 4 of the UN Charter. It's certainly quite controversial, but it is out there to be considered. There has been very little discussion about this in Southeast Asia, predictably, because of the sensitivity of the nature of these activities, but also I think largely because of a lack of awareness that these activities have been taking place precisely because of the quiet nature of this information collection. There are a whole host of legal issues to be considered as a result of this. How do we attribute many of these activities? If attribution is at all possible, there are different levels of attribution according to international legal standards. There is the matter of technical attribution, which is possibly the easiest of the different types of attribution because technology has advanced so far and so much that it's possible to now attribute particular attacks to even specific individuals. But beyond technical attribution, there are also the issues of political and legal attribution to be considered. Political attribution is, of course, a political act at the discretion of a particular government. A legal attribution runs into questions around what sort of evidentiary standards will be used, who the burden of proof will be on, and so on and so forth. So they're very, even within the area of legal attribution, there are all sorts of legal technicalities to be considered. I'm running out of time, so let me quickly close with some thoughts on how Southeast Asia has, or rather has not, been approaching this issue. I mentioned very briefly in passing that there is some contestation about whether international law applies or not at all to cyberspace activities. The Chinese view is that international law should not apply to cyberspace because it will encourage the militarization of cyberspace. My personal view is that that ship has sailed a long time ago, to use a maritime analogy, and that it's important for international law to apply. It does apply. Many states have affirmed this, in fact. But how it applies is a matter of great debate and consideration even now at the United Nations, within the UN group of governmental experts, as well as within the parallel track at the UN of the open-ended working group. This has been an open question for at least 5 years, if not more. And the can keeps getting kicked down the road because it's so controversial. How exactly each of the provisions of international legal articles and conventions apply is one of great discussion amongst states. There has been, I've not heard of any discussion within the ASEAN circles about this matter. And I think particularly with recent developments, namely Singapore's establishment of a dedicated digital agency related to cyberspace and information operations, that the time is ripe, past ripe in fact, to consider rules of engagement in cyberspace, especially when it intersects with the maritime space or even other domains. And to have serious discussions, whether at the defense level or within political and diplomatic circles, on some of the norms that should apply in cyberspace, perhaps even for this discussion to be included as part of the Code of Conduct negotiations, and then have more concrete negotiations, discussions on how exactly international law applies in cyberspace with specific regard to the South China Sea dispute. There are numerous legal experts to carry this through, but it also requires political will. And so hopefully there will be some discussion initiated, whether behind closed doors or in more public settings, such as the one that we're having now, and I hope this can provoke certainly more conversation in the region. So let me pause here. Thank you.
Well, thank you, Alina. I think ambassadors should be able to award honorary doctorates. So at least for the remainder of this conference, you will remain Dr. Noor. Thank you for your comments. I am sure there will be lots of questions at the end. I'd now like to turn to Professor Robert Beckman. Professor Beckman is from the Centre of International Law at the National University of Singapore. It's always good to have a Singaporean on the stage. Professor Beckman, the floor is yours.
Is it working? I'd like to thank the organizers for inviting me back for, I think, is the 12th or 13th time. It's always a pleasure to come back to DAV. I've been asked to speak about aviation safety in the South China Sea. I'll run through some slides very quickly, for I hope the speed readers can keep up with me. First, the role of the ICAO in the safety of air navigation for commercial airlines. The ICAO is the International Aviation Organization, governs safety of commercial aviation. They have established flight information regions, which are managed by air traffic services authorities. Civilian aircraft are required to file flight plans with the authorities before entering the FAR. State aircraft are not required to fly to follow flight plans or to submit their flight plans, but they are to contact the ATS activity but they may do so. State aircraft are required to fly, however, with due regard to safety of other aircraft. Safety of commercial aircraft is not a major issue. There are the flight information regions in the South China Sea. You see tiny Singapore has a very large FAR, and then it goes in Malaysia to the east and Vietnam to the north. More interesting are the incidents giving rise to concerns on aviation safety in the South China Sea with respect to state aircraft. We go back, way back to the original incident, if you want to take a look at that, the EP3 incident off the coast of Hainan, U.S. spy plane back in 2001. 2020, China expressed concern in the press about U.S. spy planes in the South China Sea were creating a risk to civilian aircraft when they went near the Chinese coast. May 2021, there was a lot of press about a Chinese aircraft passing through the Singapore FAR and then into the Malaysian FAR, coming about 60 miles, I think, from the Malaysian coast. That was, we look at it as a large number of Chinese aircraft came in, transport planes from the People's Liberation Air Force. Went through the flight information region of the Singapore and then that of Malaysia. Elicited a response from the Royal Malaysian Air Force. Royal Malaysian Air Force statement after the event regarded it or made a statement that it was a serious matter that threatens the national security and aviation safety. China's foreign ministry countered by saying it was conducting a routine flight training session. There was another incident that's made a lot of press in 26 May 2022. Chinese intercepting an Australian aircraft, P-8 maritime surveillance aircraft over the South China Sea. Australians complaining that the dangerous maneuvers had created a safety issue with respect to the Australian aircraft. Chinese statement after it said that this was near the Paracel Islands, known as Shisha in Chinese. Chinese made a statement that they approached the Chinese territorial airspace of the Shisha Islands, and they seriously threatened China's sovereignty and security. So these are the kind of incidents that give rise to threats to security in the region. There, the Paracel Islands are the up near, in the map on the left, it's right to the corner of that upper purple or the orange triangle near the island of Hainan. Over on the right side of the map, you see the Paracel Islands with straight baseline claims around them. The U.S. and Vietnam and several other countries have challenged the legality of the straight baselines. The U.S. has done phone ops through the Paracel Islands to make it clear that they don't accept these straight baseline claims, because straight baselines are only allowed for archipelagic states, for mid-ocean, no, not mid-ocean archipelagos, and straight baselines, of course, are permissible along the mainland coast, but not for offshore archipelagos such as the Paracels. Now, the law of the sea, I'm an international lawyer, so we better know something about, say something about the law. Again, issue first is it airspace subject to sovereignty? States have sovereignty, obviously, over their land territory, their internal waters, territorial sea. Archipelagic states have sovereignty over their archipelagic waters. No right of overflight over areas subject to sovereignty, with two exceptions. The right of overflight exists in straits used for international navigation. The right of transit passage includes overflight right. And with archipelagic sea lanes passage through major archipelagos like Indonesia, there also includes archipelagic sea lanes passage includes overflight. Freedom of navigation, areas not subject to sovereignty, which means everywhere outside the 12-mile territorial sea limit from sovereign territory, which the U.S. refers to as international waters, and Chinese always correct them and say that term is not used in international law. There's no such term as international waters, but basically it means the waters outside the territorial sea limits of any state. There's freedom of navigation. The high seas freedom of navigation applies anywhere in that area. And in the economic zone is a major issue. The major source of contention are overflight rights in the economic zone. The position of the U.S. and other Western powers that the freedom of navigation applies. Article 58 says the freedom of navigation and overflight and other internationally lawful uses of the sea associated with that freedom apply in the economic zone. And therefore, freedom of overflight. The one limitation on that is the state exercising the right must give due regard to the rights and duties of other states. And follow the laws and regulations of other states adopted in accordance with the convention. Convention doesn't give you the right to regulate it, you don't have it. U.S. position, again, military surveys are permissible. It's an lawful use of the sea relating to the freedom of overflight. To a mapping and survey law, this is the crux of the issue. Many of the Chinese laws now apply to other sea areas under the jurisdiction of the PRC. And the question, what does that mean? The 9-line map and the accompanying statement said China's jurisdiction in the relevant waters sea-attached map. There's other legislation of China, again, it shows the map and how many islands are controlled by which countries. The circled one is Mischief Reef. The militarization of the islands has obviously created a need for, at least in the Western view, surveillance of those islands, and therefore there's encounters. There's a 2014 U.S.-China MOU on safety of air encounters. That's available in the U.S. Commander's Handbook, which is available online. You can take a look at that. It calls for memorandum of understanding to limit the risk of air and sea encounters, and there's clear rules on safety of air and maritime encounters, which is intended to ensure that air-to-air encounters by naval forces are limited in terms of the risk. I just call your attention to that. There's a third annex. The air rules make it quite clear that there are some guidance which the two forces should be using when confronting each other outside of territorial sea. Because of time limitations, I can't say more than that. Air rules are clear. And then there's the question of ASEAN. My final comment is that the ASEAN and safety of air navigation, the latest joint declaration of the ASEAN defense ministers, calls for freedom of navigation and overflight, self-restraint in the conduct of activities, avoid action that would complicate or escalate the disputes. My final slide is that joint declaration also calls for guidelines for air military encounters, and that again is the message is if we use the U.S.-China MOU as a starting point and we follow what ASEAN is saying as they move toward a COC, is some confidence building measures with respect to air military encounters, we're likely to be able to deal with the issue and prevent encounters that create a crisis. Thanks very much for your attention.
Thank you, Professor Beckman. Yeah, serious incidents indeed. The one thing your presentation didn't address was how we're going to solve this problem. But maybe that'll emerge in the Q&A, the declaration. Yeah, no, maybe that's not for the lawyers, it's for the politicians and diplomats. The next speaker that we have is Professor Renato de Castro. Professor de Castro is from Strat-Base ADR Institute in the Philippines, and I think also De La Salle University in Manila. Professor de Castro, the floor is yours, sir.
Good morning, ladies and gentlemen. But before I start my short presentation, let me express my utmost appreciation for the organizer for inviting me again, bringing me back to this network of the Diplomatic Academy of Vietnam. Great arrangement, except for one thing. When I was checking in for my flight to Ho Chi Minh, the attendant told me, "But sir, your name here is only Castro." They removed the "de." So you find it very amusing. But then I realized, if when I'm in China, they would also drop the "de" and simply focus on Castro. So it makes me wonder why in two socialist countries, they always think I am related to somebody in Central America. But the danger there, of course, is the fact that if I'm associated with this other gentleman, if there are Americans around, I'll be in a hell of a trouble. So my presentation today will be based on my paper, which is looking at Chinese gray zone operation directed against the Philippines. My presentation will be made up of just 3 parts. Number one, a sort of conceptual discussion of what do we mean by, interestingly, a term that has not been used in this conference, gray zone operation. Although this was used, a different term was used by my friend from Japan, or now in Czech Republic, Professor Takashi, who used the term hybrid. But I would use the term gray zone operation. Then I will talk about cases of gray zone operation directed against the Philippines, and of course its implication, especially towards an administration, in the last 6 years that had adopted a policy of appeasing China. So let me start with what happened in early 2021 when the Duterte administration was simply so focused on the COVID-19 pandemic, trying to mitigate the effect of the pandemic. Suddenly, of course, you have the passage of the new Chinese Coast Guard law that came out in January 2021. Then, of course, an incident that I'll be discussing later, the Winson Reef standoff, which, of course, shocked the Duterte administration, given the fact that, of course, in 2016, the Duterte administration thought that it's, the best way to deal with China is basically to have a rapprochement with China or adopt a policy of appeasement. Now, let me just give a very short discussion of what do we mean by Chinese gray zone operations. So, we have a number of definitions here, but the one definition I would like to adopt is, of course, a use of all instruments to achieve political goals short of armed conflict. Some terms that use operation short of actual war, or sometimes they use the term political warfare, or paraphrasing Clausewitz, an extension of war by other means, using political measures. Of course, in the case of China's approach towards the South China Sea, it's the application, for example, of law enforcement agencies. Specifically, of course, before you have the Chinese Coast Guard, you have several civilian maritime surveillance units, so forth and so on. But of course, since 2013, you have, of course, the creation of the Chinese Coast Guard, and also the use of, what they call the third wave in Chinese maritime expansion, a force that China has refused to acknowledge, the maritime militia. And of course, again, when we talk about Chinese gray zone operation, I cannot help but remember a classic quote from Sun Tzu, Art of War. The essence of Chinese gray zone operation is to win without actually fighting. Now let me proceed to cases. We have been always at the receiving end of Chinese gray zone operation. Of course, we're on the same league as Japan, but Japan, of course, has a capability to basically withstand Chinese gray zone operation, not in the case of the Philippines. So it's always a one-sided affair. So, of course, the starting point will be what happened in Mischief Reef, 1996, when we saw Chinese huts discovered by the Philippine Navy on Mischief Reef, and the Chinese told us those are just shelter for Chinese fishermen, 1996. tell that to the Marines. Right now, of course, Mischief Reef is considered the Pearl Harbor of China and, of course, South China Sea. Then, of course, the historic Scarborough Shoal incident, 2012. You have a standoff between the Philippine Coast Guard. At that time, you still don't have the Chinese Navy. You have, of course, the Chinese Maritime Surveillance Unit. Just breeze through this. There was an effort, of course, on the part of the State Department to broker a deal for a mutual withdrawal of Philippine and Chinese vessels. In June 2012, we withdrew our Coast Guard vessel. Of course, China took control of Scarborough Shoal. And, of course, the rest is history. It's very embarrassing, of course, for the Obama administration. Something, of course, that the Biden administration took into account when it came into power in 2012. Then, of course, we have the Duterte administration who thought that the best way to deal with China is to simply appease China. So appeasement took two forms. Number one, of course, trying to distance the Philippines away from our only treaty ally, the United States. Then, of course, basically adopting China's approach of bilateral consultation. But what did the Duterte administration got? So you have several cases of gray zone operation, warnings against Philippine aircraft flying near Chinese-settled islands. You have, of course, the confiscation of Filipino fishermen catch off Scarborough Shoal. Then you have two interesting cases. Number one was, of course, the sinking of a Filipino fishing vessel in what we call a reed bank. You know, it was sank by a suspected Chinese fishing boat manned by the Chinese militia. 12 Filipino fishermen were left on the sea. Thank God there was a Vietnamese fishing vessel nearby. And this is, of course, a reflection of ASEAN solidarity. The Filipino fisherman was saved by the Vietnamese fishermen. It's something that the Philippines always look at Vietnam, a sense of gratitude, debt of gratitude for that incident. Then, of course, you have the very interesting case of, happened in February 17, where, of course, you have a Chinese corvette directing its gun control system against a Philippine frigate. Interesting case, because 2 weeks before that, President Duterte abrogated the visiting forces agreement. That would have possibly made the Chinese so happy, yet you have this very clumsy incident. And this basically made President Duterte think twice about the wisdom of appeasing China. Then, of course, the needle that broke the camel's back was, of course, the Winston Shoal incident, where the Philippine Coast Guard noticed the presence of about 240 Chinese fishing vessels suspected to be manned by the Chinese militia. And, of course, this triggered another standoff. In this respect, of course, the officials of the Duterte administration took a very vigorous stand of basically confronting the Chinese fishing vessel by sending the Philippine Coast Guard and, of course, the Philippine Navy. The Japanese government was very happy because finally the 10 multi-purpose vessels donated by Japan were being used in the South China Sea. I remember the Japanese embassy was complaining they were being sent elsewhere, but not in the West or the South China Sea. So let me just discuss the implications of this. Number one, of course, it made the Philippine government realize, specifically President Duterte, that it's simply not worth appeasing China. So the latter part of the Duterte administration was marked, of course, by a more forceful approach vis-a-vis China, realizing the folly of an appeasement policy. Number two, of course, it basically undermined the basis of the Duterte administration appeasement policy. Aside from the fact that, one of the quid pro quo regarding this appeasement policy, Chinese investment will enter the Philippines. You just have simply promises, but empty promises. $26 billion, nothing. Small amount of money came from, of course, the vigorous, unabated, vigorous Chinese gray zone operation conducted in the Philippines, and of course, forced the Philippines again to move towards its, alliance with the United States and recognition of the importance of the security partnership with Australia, Japan, and other countries, even, of course, with the European Union. And more importantly, of course, it made the Filipino public realize that it's not worth really getting close to China. The lesson here is whether you appease China or not, you will get the same treatment. So I end my presentation here. I look forward to a very interesting interaction. Have a great day.
We're Renato, thank you for that. I was about to give you an extra 10 minutes. I could listen to you all day. The final speaker on our list is Colonel and Associate Professor Libor Kutei, who is the Vice Rector for External Relations and Internationalization Director of the Institute of Intelligence Studies at the University of Defense, Brno, Czech Republic. And Professor, I think you've amended your presentation in light of the discussions that we've heard at this conference. So the floor is yours, sir. We're looking forward to hearing from you.
Thank you, sir. Good morning, everybody. Ladies and gentlemen, firstly, let me to thank the Diplomatic Academy of Vietnam inviting me here, inviting someone who is a citizen of the country which has no sea, you know. So believe me, this is a very amazing time for me here. As a European, I know that it's very sexy to compare the situation in Ukraine with other parts of the world and look for possible similarities and implications. Allow me to focus only on one aspect that was reflected in various documents of strategic importance in the past. But the reality exceeded our expectations because predicting something and believing that it will actually happen does not necessarily mean the same. Let me now elaborate something more about was already mentioned by the Joint Commander of French Naval Forces here in the Asia-Pacific region. Big attention was brought to the damage caused to Nord Stream, a system of underwater gas pipelines from Russia to Germany on the seabed of Baltic Sea. The Nord Stream is the longest underwater gas pipeline on Earth, stretching 1,224 exactly, to territories of Russia, Finland, Sweden, and Germany and Denmark. Each pipeline is able to carry more than 27 trillion cubic meters of gas every year. The damages of Nord Stream spark speculation of deliberate attack on the pipeline. The countries in West, it means us, you know, especially in Europe, accuse Russia as assailant, finding a motivation in destabilizing the region and to send a message of the vulnerability of the alternative European infrastructure. If this accusation is considered, it means further escalation of the Ukrainian conflict and a continuation of hybrid warfare. That's how we got to the bottom of the sea, where is the significant infrastructure. The sabotage of Nord Stream gas pipelines remind us to the vulnerability of undersea infrastructure, and it turned about that, for example, internet networks are practically unprotected. At the same time, the disruption could be a massive consequences. The vast majority of intercontinental data transmission reported from 97 to 99% takes place over a network of fiber optic cables on the seabed. Their location is now to everyone, and no one effectively prevents them. It has been known for a long time. The internet depends on cables. They are not protected either by law or de facto in practice. At the same time, they are relatively easy to destroy and difficult to repair. It has been developing underwater sabotage capabilities since the Cold War. The topic by itself would be enough, not for only the whole conference, but it will stay with current sabotage capabilities, and we can divide them into 5 areas. The first, large submarines. The second, special spy ship. Third, the underwater drones. 4, the piloted underwater vessels. And the 5th, trained marine mammals. There is a considerable level of uncertainty in everything. Although experts have come to believe that a complete blackout is probably not imminent. They are no longer convinced of how big the outage actually are. No one knows very well how big an internet outage would be enough to disrupt key infrastructure or even banking. We don't know how long the repairs would take or if there are enough ships for them, or even the cables themselves, since companies only stock a limited amount. Most countries have no idea to what extent their critical infrastructure, financial sector, or digital agriculture is dependent on the internet. Many potential problems, such as the cascading effect, are not explored. There are studies, but we lack direct experience. Nothing like this has ever happened on a large scale, and no one knows what it would look like. In fact, state government and security forces, services, have the answers to this question, but they keep the secret. Some countries are better prepared than others, but in general, awareness of this problem is not on a high level. Critical infrastructure is in the hands of about 2,000 or 3,000 private operators. The position of the underwater infrastructure in the legislation is also problematic. The cables stretch across international waters where anyone can approach them with impunity. Moreover, the cables belong to private companies, so their possible destruction does not even have the clear nature of an attack against the damaged states. Defending cables is not easy, even in exclusive economic zones. However, cables protect themselves simply by having too many of them. At the moment, the strongest protection of underwater internet cables is their increasing number, which makes it much more difficult to attempt a blackout outside particularly vulnerable places, which are mainly remote islands. In addition, cables often have a much larger transmission capacity than is actually used, which means that if one of them is cut, data can easily be sent via another functional cable. However, relying only on the facts that there are simply too many cables for someone to destroy is enough. Even the rapidly developing technology of satellite internet would not save us in case of extensive blackout. The current capacity is suitable for covering outages on the island or, for example, one country, but not enough for the entire continent. It's absolutely necessary to start developing the defense on several levels. According to experts, one good way to ensure the safety of underwater internet cables is to use a new type of cable that already has sensors inside it, capable of monitoring of surroundings. However, this cannot be relied on the short term, as cables are usually replaced only when their useful life, which is around 25 years, expire. As tools for a safer seabed, we can mention underwater autonomous drones that could act as relatively inexpensive patrols in the immediate vicinity of cables. Hopefully, the days of the last month will take us up and wake up us. After the sabotage of Nord Stream, we will start to act in the area of its infrastructure. But of course, the road to safer underwater infrastructure will not be easy. Maybe this problem is one of the real ones which show us even in the harsh, peaceful Europe today, nothing is impossible. And as only a few people could imagine the sabotage of critical infrastructure on the seabed, I know that other forms of disruption of underwater critical infrastructure will be a reality in the future of the relationship between countries that will be able to apply hybrid forms of warfare. Because I'm the last one, the last speaker before the lunch, please let me finish here and to thank for your attention. Thank you.
Thank you, Libor. That was interesting and scary. While you were speaking, it occurred to me that I don't think I've heard the words 5G used at this conference yet. It's probably the first conference I've been to where it hasn't been mentioned. But when I'm thinking about digital infrastructure and vulnerability, it really goes to the core of that. Look, that's terrific. I'm amazed and pleased to report that the speakers have been so disciplined that we're actually ahead of schedule. So that gives us either more time for Q&A or for an early lunch break. Obviously, I'm in the hands of those who are in front of me. I see one question. Leszek, proszę bardzo.
Thank you, Andrzej. Now, my question is directed to my colleague Renato. Those of us who have been very concerned about events in your country, particularly after the election of your President Duterte in 2016, welcome the clarification that you've given us today about the Philippines, because we were very concerned about his effort to undermine the 2016 arbitral tribunal ruling, and that was quite disturbing for the rest of ASEAN and also for maritime law in the South China Sea. And you mentioned that the Chinese maritime militia has closed off access to these reefs, to Scarborough Shoal, and also to Whitsun Reef, which was quite a disturbing incident. So my question is, given that the Philippines has passed this Duterte phase, and you now have a new president, Marcos, what are the options for the Philippines in dealing with the Philippines, dealing with China? As a small country with a very limited maritime capability, you'll be starting from scratch. So what can the Philippines do?
Dziękuję. Yes, I have a question at the front and I have one at the back. So the gentleman in the red tie at the back. Microphone, please.
My name is Nguyen Bagong. I'm director of the Scientific Research Institute in Sea and Island. I have one question for Professor Renato de Castro and also for Professor Beckman. My question is, 1 month ago when I was in Washington, D.C., and the leader of the 7th Fleet of the U.S. Navy said to me that there's idea that U.S. Navy would like to send their vessel, U.S. Navy vessel, to any coast state to have the law enforcement force of the coast state which they wanted. So I was wondering, how do you view that, the idea that one day the Philippines government invite the U.S. Navy vessels to have the Philippine Coast Guard to counter the Chinese law enforcement in your EZ? My second question for Professor Beckman, that how do you view the legal aspect of the activity that country A invites a Navy vessel or country B to have you counter the law enforcement of country C in the EZ of country A? So how do you view the legal aspect of the activities? Thank you.
Okay, thank you for that. I'll take 2 more questions before we go to our panel. Sir, you have the floor for your question.
Thank you, Ambassador. I have one question for Professor Beckman and one question for my good friend from the Philippines, and a general question for everybody at the panel. Professor Beckman, some years back we heard that China want to establish what they call the air defense identification zone. And all of a sudden, things died out. China have not pushing forward for it. Why is that the reason? Can you explain? Because from the American side, they've been raising the activity on this overflight. So, what have, in your view, why is it China does not want to make it? They don't want to declare the ADIZ. Question for my friend from the Philippines, following from Professor Desik. In January 2013, the Republic of the Philippines take initiative to initiate the arbitral process proceeding against China, and then 2016, there's a landmark PCA awarded in favor of the Philippines, and then now you have a new president. We know that during President Duterte, things sort of dressed up under the carpet. The Philippines did not take any initiative to pursue the PCA. But the reason I ask is because before the AMM the AMM meeting, the foreign ministry meeting in August in Cambodia, there was some rumor that the Philippine envoy, your foreign minister, he didn't come finally because it was just. But there was a rumor that you will ask the Cambodian chair to put that on the table, and that's why I like to hear you how you see the Philippines taking forward this PCA, if any, under the new president. And one question for everybody here, as this panel discuss the applicability of the international law as a whole from cyberspace, my good friend Elena have spoken highly about the issues, and everybody also speak about how China is not in favor of international law. So, in fact, I want to ask this question to Judge Krysak yesterday, but no time. I'm not a lawyer, but I'd be very interested in hearing your view, how you enforce that, because yesterday we talked about the COC, the enforcement of COC based on international law. But if you cannot get China to agree to it all the time, it's been too long now. The applicability of UNCLOS over big state. Is there anything that you can offer to people like me who don't really understand international law per se? How you make it so that people still have a belief in it? Thank you very much.
Okay, thank you. I'll invite one more question in this round. I would particularly welcome a question from one of the women participants. And please don't forget my friend Libor, who knows about, his expertise extends beyond undersea cables. You guys don't qualify. Okay, I'm going to be stubborn, and we're going to go with those questions for this round, and then we'll do another round, and gentlemen, I will accept you at that point. Okay, so we have questions to the panel generally, and also specific questions to individuals. Robert, can I invite you to go first, or Renato? Robert.
Is this working? Yeah. I must apologize because my 79-year-old ears did not completely understand all of the questions. The first, from the speaker in the back, could somebody summarize his problem?
Could you just, in one sentence, quickly summarize the question about the invitation of country A to deter country B in country C?
My question is simple. Can a country can invite a Navy vessel or another countries to conduct law enforcement?
So,
Can country
every
A
state,
can,
as a matter of their sovereignty, could invite another navy to help patrol its waters. Question how many states would be willing to do that. I think the problem I see with the South China Sea and naval activities is that Chinese is putting their Coast Guard in. Other countries' navies are going through, but your agreements are Navy to Navy and Coast Guard to Coast Guard, and you don't have hotlines to deal with Navy versus Coast Guard. And I think that's a fundamental issue that has to be addressed. Right? The U.S. and others are sending their navies through. The Chinese, they're calling it their Coast Guard, and then there is no hotline between Coast Guard and Navy. And I think that's a gap that has to be filled. Now, if that I'm very sorry because there's no speaker behind me and I cannot catch the problem. And his probably question over here is related. The 80s. I think the 80s has not caused any major issues. The 80s of China, in my view, I did a paper on this, I could send it to you. The 80s of China is actually quite reasonable compared to that of Japan and the other countries. I'm not sure that the 80s has had any practical impact. To my view, the 80s has not enhanced or has not increased the level of security risk at all in the region. The 80s simply generally means if you're going to enter our territory, give us notice. The overlapping 80s between Japan and Taiwan and China in the East China Sea is, I don't think it's caused that many difficulties. The Americans are responsible for most of the 80s because they created them initially. China has not created an 80s in the South China Sea. I think, again, we did a paper on that. I don't think it would enhance, I don't think it would help or hurt the situation that much more if they did. And I think they've realized that, and that's why they have not declared an 80s. To me, the 80s made sense with respect to the original one between the US and Canada versus the Soviet Union and the fear of bombers coming over to bomb San Francisco, I guess. But in terms of Southeast Asia and East Asia, I don't think the 80s have had any impact. That's my own view.
Thank you. Renato, you received a couple of questions, and then the question about cyber law I'll refer to Elena and Libor before we go to the next round. Renato.
Okay, this is on. First address a question raised by my very good friend Leszek. But before I address your question, let me just make a clarification. In the Philippines, we don't anymore consider ourselves as a small country. We basically adopted the accolades based from the Australian assessment. Lowy Institute, we're a middle power with a population of about 110 million. And of course, we provide labor to the world. I don't think we could consider ourselves still a small power. We have some problems regarding military capability, but I assure you, we would catch up sooner than later. But of course, we rely more importantly on our partnerships with Australia, Japan, South Korea, and the United States. Okay, let me address your question regarding the arbitral ruling. Actually, as early as the time of the Duterte administration, there was already a recognition that it's time to acknowledge. So by July 2020, he finally acknowledged the ruling. And of course, last year of his terms, there was an acknowledgement. But what differentiates this current administration is the fact that even before he got inaugurated as the 16th president, he already acknowledged the ruling. And in fact, during the anniversary, it was acknowledged by our foreign secretary. And interestingly, I noticed there is a budget in the Department of Foreign Affairs for the Department of Foreign Affairs to, in every international forum, the ruling would have to be mentioned. And regarding Cambodia, we don't intend, to hard sell the ruling, but basically it's the prerogative of our diplomats to raise the ruling and emphasize the fact, despite any country's effort to undermine the ruling is carved on stone. So let me be emphatic about it. It's there. It will be studied for ages, no matter how countries would basically say, the Permanent Court of Arbitration is not part of the UN. We won that case, and people for posterity would always remember that case. Okay, so that will be our position. No hard sell, but we would basically ensure that the ruling would not be undermined for whatever reason, by power, sheer power, whatsoever. So again, then let me address the question of what would be the foreign policy of this current administration. I think it is more of a balance, that we have to engage China economically. It had to be based on the bedrock of our, traditional ally and security partners, the United States, Australia, Japan, and of course South Korea, and of course Vietnam. The only way we could deal with China as a middle power with limited capability is to rely on our partnerships, good old reliable partnerships. But of course, again, this is my critique as an academic. Maintaining a balance for the Philippines is easier said than done. For one thing, of course, we are a treaty ally of the United States. If you're a treaty ally like Australia, Japan, and South Korea, we cannot basically, maintain neutral in all other issues, especially if the alliance will be tested. And, I bet sooner or later that alliance will be tested. I hope not, but there are indications that it might be tested, and that's where we cannot basically apply a policy of neutrality. Now, regarding the Coast Guard, I think it will be the Coast Guard, not the U.S. Navy, not the Philippine Navy, but it will be the U.S. Coast Guard. Although there's a possibility that the joint patrol between the U.S. and Philippine Navy would be resumed, given what was agreed upon in Hawaii about a couple of weeks ago, when you have Lloyd Austin and the officer in charge of the Philippine Department of National Defense basically raised the possibility that joint patrols, not only with the United States, but possibly with Japan, Australia, and other like-minded countries would be resumed. Thank you very much for your attention.
Thank you, Renato. Can I just make one observation? I think being a small country is more a state of mind than a function of actual size. That's my experience. We have some very large, small countries in this region, but I'm glad Philippines isn't one of them. So we have a question about cyber law. Alina, I know you've kind of addressed that in your remarks, but I would appreciate anything further that you would like to say, if there is anything further to say. And Libor, I'll invite you also to comment on any of the matters that have been raised in this round. So Alina, you first.
Thank you. As always, very sharp observation by Ambassador Sutira. This is a difficult question, of course, because as you pointed out, China does not accept that international law applies in cyberspace. And it's actually pushing for a separate treaty on cyber law, which hasn't gotten much traction. But absent a particular treaty on laws that relate to cyberspace, that will just take forever to negotiate. There are 11 norms of responsible state behavior in cyberspace that were mooted by the 2015 iteration of the UN Group of Governmental Experts, and that have since been accepted by the UN General Assembly. And those 11 norms can be applied to situations, incidents in the South China Sea. The norms include basically what is expected of responsible state behavior in cyberspace, including international cooperation on security issues in cyberspace, including not attacking critical infrastructure. So Andrew, you talked about digital infrastructure. The norms relate to that and should be observed. And at the very least, if there cannot be a clause that specifically relates to the application of international law in cyberspace in, for example, the Code of Conduct, then there should be a reiteration of how important it is for all state parties, or whatever the term is to the COC, to observe what has already been universally agreed upon in the shape of the 11 norms of responsible state behavior in cyberspace. So that should be made very clear in the language of the final edition of the COC.
Thank you, Alina. Libor, on any of those subjects.
Yeah, thank you very much for the word. There is many times when the PRC was mentioned yesterday, today, and this panel as well, So, and there's some question about, how to stop, etc. Usually we look on China as a big dragon, bear, Asian bear. In Europe we have another bear, Siberian bear, the Russia. And especially us, you say the middle state, in Europe, it was always a big threat and a real threat for us. And look what happened now. And this is something, ladies and gentlemen, we can learn from Ukraine, from what happened now from Ukraine. We can learn from this. And this is international solidarity, united approach, and international isolation of aggressor. This is something what works now in Europe. There is no European country seriously talking to Russians. or let's say, and wanted to the solution according to Russian interest. Of course, the PRC are a bit different. There is a lot of many political, regional, and economical interest. But the protection of economical growth and social stability is the main point and the main target of the PRC's government. So the question is, who will affected more by the potential sanctions, by the international isolation, etc. You know, this is about the question how to stop if something happen by the something using the military force. Thank you.
Thank you, Libor. Okay, I'm going to test the appetite of the audience for more discussion or for lunch. Okay. And unfortunately, the women have let me down. Okay. Oh. I don't see. Ambassador Kui? Okay. I can see Ambassador Kui, yeah. I was looking for other participants. Okay. Look, in order of those who have asked, my colleague from the middle rows, Admiral, I'm going to maybe give you a pass at the moment because I think we've heard a bit from you, which has been great. Ambassador Kui, the gentleman in the mask, yes, Carl, and okay, Admiral, if we can keep the questions short, we can get through all of those before lunch. Thank you very much. So, first.
So my question is directed towards Libor, but also to the rest of the panel. If you feel it's appropriate with personal experience, please answer. So thoroughly agree, fibre optic cables are crucial infrastructure, and when damaged or destroyed, it's really damaging to the economies of many nations. What I'm really interested in to hear about from your perspective as well as from the region, what are some good rules of the road for negotiating right to repair and access to repair these cables? Because quite often, they're rendered inoperable not maliciously, but from fishing vessels or anchors being dragged through them. This may be a scenario for future disputes, especially in these heavily disputed waters in the South China Sea. And how do you see the best way forward for negotiating regular access by certain nations?
Thank you for that. Next one was Ambassador Kui.
Yes. Thank you very much. I have a quick question to Professor De Castro. Is there a well-defined area that covered by the mutual defense treaties between the Philippines and the U.S.? And how about the case of Scarborough Shores? Thank you. Yeah, thank you very much.
Thank you. Professor Carl?
Just briefly, two clarifications, and I'd like to talk to Bob Beckman if you can hear me. The first, I think the question you were asked is, what is the legality of the Philippines inviting the U.S. Coast Guard to assist it in patrols and actions against illegal fishermen? And my second, could you please clarify for this audience the distinction between the arbitral tribunal that heard the Philippines case and the references that have been made to the Permanent Court of Arbitration?
Thank you, and appreciating the questions are nice and crisp. Admiral, did you have a question?
I just wanted to add on to the question that was already asked by my Australian counterpart, and that is to do with underwater cables and the landing stations. And actually, because underwater cables are not owned by anybody in the government, and they have segments that are owned by different international combinations, how on earth are we planning to even begin to assign responsibility since the flag state principles will not apply? Different segments of the same cable have different owners. How do you think that this might be worked out in law? Thank you.
Thank you, Admiral. And look, I didn't realize we have 2 questions from online, and let me quickly read those out. And the panelists will need to do their best to figure out how they answer all these questions and in what order. Okay, so a question from Linji Hong, Amy, the YLP's panelist from Singapore, for Professor Renato. If China offers economic incentives again today, do you think the Philippines will once again be willing to appease China on the South China Sea conflict? Where do economic priorities stand vis-a-vis the South China Sea conflict for the Philippines? Thank you. I think you kind of answered that, but I'm going to let you have another go in a second. And a question from Paul from Australia for the whole panel. Space is ever more vulnerable to grey zone activity. What strategies are being pursued in the Asia-Pacific, these days we say Indo-Pacific, but okay, regarding protecting space assets? Is the US space domain awareness capability relied on? Okay, I think that's plenty of questions. I will invite, well, Renato, why don't you go first and the others can gather their thoughts.
Let me first address a question if the Chinese would offer, again, economic goodies. I think the Filipinos will have already learned something from, I don't know if you remember Iliad, you know, when the horse, the Trojan horse was being brought. I'll just have to paraphrase it. Beware of the Chinese giving gifts. Right? Beware of the Chinese giving gifts. I think that is a lesson that we have learned from this. And of course, we have other options. Japan is a very good option. In fact, the largest public sector investment in the last 6 years is not because of China. It's because of Japan's generous contribution to build, for the first time, a subway system in Manila. Of course, that's a hell of a challenge because Manila gets flooded. So it will take a lot of ingenuity from Japanese technology to ensure that those subways would survive a major flood. Now, let me address the question of the geographic. This has, of course, been an area of contention in terms of how you define, you know, what basically constitutes an area that will be considered legitimate, you know, to invoke the Mutual Defense Treaty. In 1997, of course, this came out during the negotiation for the Visiting Forces Agreement, when you have a letter from Ambassador Thomas Hubbard, that the South China Sea is part of the Western Pacific. So, you know, the treaty provides any attack on Philippine public vessel, you know, in the Western Pacific would be covering ground. And again, reaffirmed by then Secretary Michael Pompeo when he went to Manila in March 2018, again reiterating. But of course, the issue here is not really the geographic space, because the Mutual Defense Treaty also provides any attack on Philippine public vessel. So whether it's in the East China Sea, whether it's somewhere in the Pacific, will be a ground to invoke the Mutual Defense Treaty. But again, the bottom line, if you look at the Mutual Defense Treaty, like other U.S. Mutual Defense Treaty, it simply provides for mutual consultation.
Thank you. Elena, can I invite you, then Libor, and then Robert to address any of those questions that you would like to touch on?
None of those questions were addressed to me, so I'll cede my time to Libor.
Okay, if you change your mind, let me know. Libor, go for it.
Okay, about the cables and let's say the international waters and etc. You know, firstly, I'm not lawyer. I'm a military, and we always use the force, or at least the terrains of force. Maybe it's a good topic for the next conference. You know, the law of the cables. You know, so international cables. Maybe 2 points. First is if we do something, so it must be very well investigated before. As we can see even today in the Ukrainian conflict, there is a lot of misunderstanding, disinformation, and unclear things, and sometimes we really don't know what's really going on and what really happens and happened. This is the first one, you know. So about the cables, even the Nord Stream, we believe in something, not because we want, but because it's like 90% is like for whom, you know, it is. But even today we still don't know who did it, you know, so this, let's say, sabotage. And about the cables, you know, it will be very, very difficult to investigate and to point to someone. This is the, let's say, the government who is responsible for this. And then, because I'm military, use the force. You know, but about the international law, this is really not my business, and I'm coming always after. Yeah, thank you.
Okay, thank you, Libor. Robert, is there anything you'd like to add from any of those points or any of the questions?
Let me take
that
the
were addressed?
easy one first, and that is the confusion that often exists with respect to the fact that the Permanent Court of Arbitration was the administrator in the South China Sea case. Basically, it was an Annex 7 case, which means it went to arbitration, and therefore somebody has to be the administrator of the case. There's a body in The Hague called the Permanent Court of Arbitration. They simply provide the administrative service and the facility for the case. They are not an independent court. This was a decision under Part 15 of the Law of the Sea Convention. If you go to the Tribunal for Law of the Sea, the case is administered by the tribunal itself. But if you go to arbitration, it's administered by the Permanent Court of Arbitration. They're not a UN body. They simply are a body that takes care of the note-taking and arranges the meeting, et cetera, et cetera. So the decision is legally binding under Part 15 of the Law of the Sea Convention on both parties to the case. That is what is critical. The idea that the PCA was the administrative body has been used by people that don't understand the law of the sea as a way to try to discredit the decision, but that's total nonsense, right? In terms of the right of the Philippine Coast Guard to request the United States Coast Guard to help it patrol its waters, again, as a lawyer, I'd exercise caution on that. What do we mean by Philippine waters? Is it the archipelagic waters and territorial sea that are not disputed? Is it the territorial sea around the umpteen islands that are also claimed by Vietnam and Brunei and Malaysia and China? I would say the U.S. Coast Guard probably should not get involved in that. In Southeast Asia, generally, certainly in my corner of Southeast Asia, Singapore, Malaysia, Indonesia, we have coordinated patrols. We don't have joint patrols. What that generally means is you stay on your side, we'll stay on our side, and we'll talk to each other when foreign vessels come in that are suspect. But I think the U.S. has a history in the Pacific and in the Caribbean of having a system where ship rider agreements where the U.S. Coast Guard will do the patrolling and they'll have a person from the, say, island state that has an officer on there, and therefore they are exercising control if they find ship carrying drugs or so on and so forth. In the sensitivities of Southeast Asia, I would caution the Philippines about inviting. I think maybe you want some training from the U.S. Coast Guard. Maybe you want some vessels from the U.S. Coast Guard. You don't want U.S. vessels to attempt to be patrolling your waters on your behalf. I would throw up a very large red flag on that issue. Final point I'll make is just on the whole issue of communications and submarine cables. We've been doing a lot of work at our center on submarine cables. I sense that the countries in Southeast Asia are on top of the issue of cyber attacks, and they all have cyber security agencies that are dealing with, but they have not thought about the submarine cables as critical communications infrastructure. They don't have proper laws in place making the attack on the cables a crime under their national laws, even though 98% of your telecommunications is coming from submarine cables under the water. I would encourage all of the ASEAN countries, take a look at this. You'll find that usually fiber optic cables are treated as an economic issue within ASEAN. It goes to the economic pillar, doesn't go to security pillar. And in countries, it usually is your telecommunications ministry that's dealing with it, and they don't talk to the security people. And if you follow the Australians, they probably have the best legislation on this. That's my message. Thank you. Satellites, again, it's another issue because satellites are owned by private companies very often. But the major powers all have anti-satellite weapons, and sooner or later you're going to have a conflict in which you're cutting submarine cables and knocking out communication satellites, and then we'll all be back by writing letters.
Thank you. I won't attempt to summarize this discussion, but I'll conclude with this observation. When I arrived in Hanoi 2 months ago, I looked at the traffic and I thought it looked to me chaotic and dangerous. 2 months on, I've revised my opinion and I'm beginning to understand that it actually works. When we look at the rules of the road for these non-traditional domains, I suspect the opposite might be true. Please thank our panelists.